Welcome to Aspen Leading Edge. I'm Patty Roberts from St. Mary's University School of Law. Today's guest is Mark Geistfeld. He is the Sheila Lubetzky Birnbaum Professor of Civil Litigation at New York University, and I'm excited to have you here.
Thank you. Delighted to be here.
You are at New York Law School and teaching in the area of products liability. You've written and taught in the area of torts, products liability, and insurance. But you have been part of the evolution of products liability to where it's cool again. You have a new book, Product Liability Law in the Age of AI. That's Aspen Publishing, third edition, that's coming out this fall. And so tell us a little bit about what brought you to this AI iteration of the product liability law book.
Yeah, okay. Good question. It actually kind of just traces the way in which products liability is evolved and developed since I first entered it teaching. I went to law school in the mid-1980s when the tort reform movement started, and tort law was politically hot topic, and you had presidential candidates suddenly railing about trial lawyers, which is always just bracket for tort lawyers. And so a lot of people who teach products liability torts, we were in law school in that era. And so there's lots of interest, people writing about it. The third restatement of torts did a separate study on products liability in the 90s that generated a great deal of scholarship. So it was a pretty hot topic for that period. And then it just dropped off the radar screen. People hardly ever write about products liability anymore, and the interest just moved elsewhere. I have a PhD in economics along with a law degree, and I wrote my dissertation on products liability. So I've just always been fascinated by products liability and stuck with it. And in some ways, I was just kind of one of the last few people standing from my generation. It's inevitably going to be important. It's practically important. It's conceptually interesting. So I never lost faith, but definitely felt like I was no longer in a cool subject area. And student enrollment in my class corresponded in the same kind of way, et cetera, et cetera.
Yeah, if I can stop you there for a second before we move on to the AI renewed interest in the field. Why do you think that there was that drop off of interest? Was it because of tort reform? Was it changes in the law? Was it changes in how the government was regulating products? I mean, why the drop off, do you think?
It's mystery because I didn't feel that. But certainly, I think a lot of it is the way that new article topics seem to get generated for people who are entering the field. So, in this era, what happened is the rise of the internet and all of that. So there was a distinct shift to like so-called internet liability, platform liability, and things like that. So I think a lot of people who might otherwise been interested in the space moved in that direction. It's again, substantively, the questions have always been the same and remain interesting. But I think it's just there's always a distinct pull for whatever topics are current in the news, and products just dropped out in that particular way. So I think a lot of the explanation just is nothing other than that.
So now your third edition is Products Liability Law in the Age of AI. So tell us about the book generally, and then we can follow up with some questions.
Yeah. So although this is a third edition, it's the first one that actually has this title. So the prior two titles were Product Liability Law that I developed in the context of teaching this class at NYU. And my wife is in the transportation field, and she quite a while ago said, you really should look at autonomous vehicles. They're pretty interesting. And I was like, yeah, I don't do specific products. I do general product issues, but it's like, so I was very resistant, but she's quite persuasive. So I started to look into it, and it was fascinating. And so I ended up writing some articles on autonomous vehicles. And I felt like I was working them through. I felt like I was taking a final exam in products liability, kind of like everything I knew at some point seemed to require application to some issue. So it's pretty interesting. When I did the second edition of the case book, I then incorporated a whole bunch of autonomous vehicle problems into the book because I could tell the field was going in this direction. And similarly, the move in legal education to have more application-oriented ways of studying material rather than the typical case book made sense to go in that direction. And then the AI, ChatGPT, right after we get get out of the pandemic comes out. And so the whole AI thing blows up. And because of my history in products in the autonomous vehicle space, I just naturally moved into AI more generally. And then, so it just made sense when I did this edition to let's just blow it out to AI. And now people are interested in products liability because of AI. So let's just rename the book Product Liability Law in the Age of AI. Substantively, it's just a continuous development, but it does definitely have what I would hope is a more intriguing title than what it used to have.
Well, what a great suggestion by your wife. I recently saw one of these autonomous vehicles as a taxi in Austin, and I guess they're trying them out in San Antonio now, where St. Mary's is located. Are they in New York already?
No, they started. Waymo has applied to get a few on the road. So what they do initially is they map it quite extensively and so on, and train the algorithms on things that are distinctive to New York, much in the same way that any human driver who goes through this gets trained in a certain way how to learn the traffic patterns. But it'll be here. It's in San Francisco. Most people, if you're in San Francisco and you go to the airport, you can just hop into a robo-taxi. LA, they're being introduced there. So it'll be interesting here because the weather obviously is quite different. So that's always one of the difficulties for autonomous vehicles. What do you do when it snows? Things like that.
Oh, maybe that's why we in Texas, South Texas and Central Texas got it early.
Yeah.
So let's just look at autonomous vehicles for a moment, because you have done a good deal of research and writing in that. What's the end result of your research and where the law is currently? If I'm in a robo-taxi and there's a crash, what opportunities do I have to go after the product or the manufacturer?
Yeah. So not surprisingly, as a law professor, I'm going to answer it depends. Because they crash for a whole variety of reasons. And so one thing I discovered when I started writing in this area is that most of the other analyses had just done a very bird's eye view of the whole thing and hadn't been adequately fine-grained about the reasons why a vehicle might crash and so on. So the most interesting question really is what happens if the algorithm malfunctions in some respect, or those cases aren't so hard. So the most interesting question is always, you're in a robo-taxi, it's working as designed, but it's not going to be perfectly safe. So what happens when it crashes under those circumstances? That's the hard question. And if you can't use the fact of crash as an inference of defect, and you might be able to in some cases, it might just be that, look, the programming just like mowed over somebody in circumstances a human driver never would have done. There just seems something off about that the design should have picked up on. And so you might have kind of easy cases like that. But if you're outside of those exceptional circumstances, is it reasonably safe or not? Ends up turning on when you get into one of those vehicles in Texas. Every vehicle that's driving around Austin has the same operating system. So the operating system is kind of driving 200 cars or whatever. It drives the fleet. It's just not driving a single car. And so what that means, interestingly, is we think of crashes on a case-by-case basis, because whether I was negligent or not just depends on this moment, doesn't depend on my general abilities to drive. But when you're talking about autonomous vehicles, it's the system, so how does it operate across Austin? Not how did it operate on September 15th at 2:05 p.m. And so then you have to look at aggregate driving data. What's its incidence of crashes across, in the relevant time period, in the relevant circumstances, and how does that then compare to the right baseline? So that ends up being a hard question. Is the right baseline a human driver? Is it a human driver in a really good car? Or is it a really good human? So you have really hard baseline questions like that. So you get into complicated questions involving general statistics and the like. And this ends up starting to look a lot like the toxic tort litigation. Does a drug, when you give it to 10,000 people, some of them end up getting a bad side effect. How do you measure that? Does it mean the drug is defective or not? And so on. So autonomous vehicles, those kinds of crashes are going to move us into that kind of space that's now occupied by the toxic torts.
That's so interesting. Well, it'll be certainly fascinating to watch how the law unfolds in this area. I read recently that it is safer, arguably, statistically, to be in an autonomous vehicle. Is that what you found?
Yeah, no. And so then, so I made the argument that it's true they're safer, but it doesn't follow that, therefore, they shouldn't be even more safe. And they continually improve, which is another problem. You don't want to say, once you're a safe safe as a human, you're okay, you're immune from liability, because you eliminate the incentive, or largely eliminate the incentive, to keep improving the safety performance of the vehicle. I think you can make a pretty good argument that if it's twice as safe as humans, that you're probably in a pretty comfortable zone if you're the manufacturer.
Well, you in the book Product Liability Law in the Age of AI, 3rd edition, you have 51 problems at the end of your chapters. I imagine some of them involve autonomous vehicles, but what are some of the other AI product liability issues you tackle in this book and that you now are part of tackling as the reporter for the newly launched American Law Institute Principles of the Law Civil Liability for Artificial Intelligence?
Yeah. So one of the nice things about that ALI project started getting put together and approved and taking off around the same time I was revising the case book. So I found I put a lot of work into this revision. It's substantially, I think the third time around is always a charm for any kind of book. But this one, knowing the direction I was going in and knowing that we're going to expand from autonomous vehicles into AI more general, I put a lot of work into it. That's been very helpful for me on this ALI project. There's already cases that are out there of teenagers or even adults forming emotional bonds with chatbots and then committing suicide due to the social isolation and so on. There's kind of related cases involving the social media platforms like Facebook and TikTok, where again, kids typically become addicted to it with harmful behaviors following from it. So there's already lawsuits going out there. And even if they're not product cases, courts still have to work through the issues because the plaintiffs routinely allege claims of products liability along with negligence. So you have to understand what's a proper product claim versus what's a proper negligence claim, pretty much for any one of these cases. So that just expands pretty much the range, not just of AI, but almost all kind of computer algorithms that cause harms. Interestingly, tort law has never really firmly answered the question of whether software is a product or a service for liability purposes. So a product is subject to strict products liability, and a service is subject to ordinary negligence liability. So we provide a service when we teach our students, we would hope. But we're not defective products. We may be committing malpractice in extreme situations, but we're not defective products. But that's how the liability rules go in those directions. And that's just going to be involved with any case involving an algorithmically caused harm. But then once you're in the product space, what I call cyber physical systems, autonomous vehicles being the most obvious example, but a robot in a factory floor, anytime you have an algorithm that is causing a tangible object to move through the world, it's properly analyzed in terms of products liability, I think. And the harder question then becomes, what about things like ChatGPT and so on that just really generates informational outputs? And not surprisingly, typically the informational outputs are more like services in the same way that we provide information in the classroom. It may be good information, it may be bad information, but it's not defective information. The only exception there is there are some kinds of information which are defective. When you're purporting to make a statement of fact or something that's objectively verifiable, it's either true or false when you make it. And so though for those kinds of informational outputs, you can analyze the AI as a product. So if medical AI, says, oh, there's no tumor in this X-ray that's been analyzed, and it says that, we're accurate 74% of the time. That's an objective statement that you can evaluate with the defect-based rule of products liability. So it's a pretty wide range of cases, physical against cyber physical systems, and then informational outputs that are really objectifiably verifiable at the time they're made.
So where do video games fall in all of that?
Yeah, video games are going to be services. So there the idea is, are they designed in a way that creates a propensity for violence, or are they overly addictive and so on? What you're really asking there is the way that the information is conveyed by the algorithm, is it overly addictive? Does it induce one to violence and so on? But you're really looking at the informational content itself and saying, is there something unreasonably dangerous about this information? And that's not an objectively yes or no answer at the time when the output is made. It's something that you end up analyzing under ordinary negligence. So you do that we'd call that a service for tort purposes, and analyze it with ordinary negligence liability. Still raises its own set of interesting questions, but it's not a products liability case.
And where does assumption of the risk fit in all of this? If I choose to get into an autonomous vehicle, aren't I assuming the risk?
Depends, which can't be the answer.
You are the quintessential law professor.
Exactly. It depends on it depends on the warning that accompanies the vehicle. So let's say, for example, to assume the risk, you have to have good information about the risk you're assuming. And so the knowledge that it might crash isn't enough knowledge. We know any product might injure us. A drug manufacturer can't say might injure you. If it knows there's a 1% chance of causing stroke, it has to say 1% chance of causing stroke. Now, in those circumstances, once the warning has been given and you take the drug with knowing there's a 1% chance of stroke, in effect, you've assumed that risk. So that if you suffer the stroke and there was no misrepresentation and that in fact is 1%, the manufacturer's not liable. And that's tantamount to saying you knew what you were getting, you choose to face the risk, you can't come into court now and say you should have never been given the opportunity to take the drug in light of the risk that you knew about. So with autonomous vehicles, lots going to turn on the adequacy of the warning, how much we know as consumers when we hop into those vehicles.
In looking at what's new in your third edition, I know that you added some cases addressing questions of liability for social media platforms, which we just talked about, but also cases that address the Amazon marketplace. So how does Amazon and its services and the products that it serves fit into this world?
Yeah, yeah. I mean, so what happens here is once you move into software and start analyzing software, of course, it's intangible. And so once we have an intangible good, its properties just fundamentally differ from tangible products and tangible marketplaces. So if you go to a brick and mortar store and buy a product, the physicality of everything that's involved there is just an up the middle products liability claim. So that if you buy a defective product at a brick and mortar store, you can sue the retailer for the defect, and then the retailer could go after the manufacturer in indemnity action or whatever. But it all works in a fairly seamless, easy to understand way with tangible products and physical stores. Once you start to introduce algorithms, whether the algorithm is the product itself, like we were just talking about, what's interesting about Amazon is now we're creating the marketplace with an algorithm. So it's a virtual marketplace, not the physical brick and mortar store. So you have that same kind of difficulty of figuring out whether there's a sufficient analogy between the brick and mortar store and the intangible virtual marketplace that is created by Amazon. And courts initially, in addressing this question, where the plaintiff purchases a defective product on the Amazon marketplace from a third-party seller, oftentimes in China, outside of the jurisdiction of the US, so you can't recover from the actual seller, you go after Amazon as the intermediary. And courts initially, and opinions that were not very well thought out, they're highly formalistic, especially when you could compare them to opinions that characterize most interesting products liability questions. Products liability is a great area because the courts are very policy driven in the way they analyze problems. So it's very rich in this respect. But the early Amazon cases were very formal. They'd be things like, well, Amazon didn't take physical possession of the product. It didn't own formal title to the product, and therefore it's not a product distributor. And so it kind of got caught up in that not adequately understanding how the intangibility of the marketplace requires you to think through the problem differently. Courts more recently have gone the other direction. They're just thinking about it functionally. And once you look at it functionally, it's pretty clear that Amazon is part of the stream of commerce in the same way that a brick and mortar store is part of the stream of commerce. And I think the easiest way to understand that is just to ask yourself, when you buy something on Amazon, do you have any expectations that Amazon's responsibilities are reduced somehow as compared to if you bought the same item in a brick and mortar store? What would be No, you don't experience it that way. And in fact, nor does Amazon really construct its marketplace along those lines. It imposes pretty demanding conditions on its suppliers, indemnity provisions, liability insurance with them named as a beneficiary, et cetera, et cetera. So actually, if anything, they've got more control over the safety that runs through the marketplace than certainly the corner deli does down the street from here, where if they sell contaminated food, I can sue them directly. But it's not really true that they have the same kind of influence over food safety in the way that Amazon might.
Well, and I think Amazon would be extra culpable for anything that I purchased there because they have been reading my mind and listening to my conversation. and advertising exactly what us.
It's a very good point because a lot of products liability, the logic of it, the justification for it, really originally stems from the way in which manufacturers create consumer demand through advertising and the like. And so if they're going to do that, they have to be responsible for the expectations that they create.
Exactly. Well, it's just fascinating, all of these topics, and it's exciting that something you already had decades of experience with is getting this kind of reboot in the age of artificial intelligence. I'm curious before we wrap up if the book covers things like deep fakes and kind of our name, image, and likeness and what AI and service providers and the internet can do with it.
Yeah, no, because those are not going to be products; they're going to be services. Because the informational output there, deepfake, you might say it's objectively verifiable. That's not me in the image; it's somebody else. But there's a separate question whether it's labeled as me and so on. So there's good questions about how does defamation apply to deepfake and so on. There's great tort questions on the ALI project. We face similar set of difficulties. There's so many ways that AI can cause harms. How do we start to structure this project in a way that's manageable? Our first move is really to focus on commercial distribute the liability of distributors and commercial distributors, product or service. How does negligence work? How does products liability work? And with deepfakes, you're really talking about the liability of users. Somebody who uses an AI algorithm to generate the deepfake that ends up harming somebody else. All hard questions, all interesting questions, but a separate kind of set of. So there, I would think, for teaching torts, that would be a classic advanced torts class, in the same way that defamation and so on. So in the same way that products liability is being transformed by AI, I think you can easy to create advanced tort classes that are centered on AI that explore these questions at depth. And we'll do that with the ALI project. And maybe after having done all of that, come back and write a casebook on this. I don't know. But I'm assuming somebody will have gotten there long before I get to that point. But they're all really fascinating questions. They're just because it requires that kind of classic common law thing of you take an established principle and established rule and you figure out how it applies to a new set of circumstances. That's pretty much what's going on here.
It really is exciting. And Product Liability Law in the Age of AI, third edition from Aspen, is available this fall for people who would like to explore these topics more. And I'm excited that you get to expand beyond product liability with the Civil Liability Project for ALI, Civil Liability for Artificial Intelligence reporting with ALI. So thank you for sharing some of your insights. I think they're hypotheticals, and we could go over the 51 problems in the book, but we try to keep this at a half an hour, so we're not going to do that today. I always end my podcast episodes by asking individuals what their predictions are for the future of legal education in the coming decade. So I'd like to give you the opportunity to share your thoughts.
Well, so naturally, this just builds on AI because, of course, it directly impacts what we're doing. So when now you do legal research on Westlaw or Lexis, you have the option to use the AI assistant, which frankly, I use pretty regularly. I used to, with the old versions, I would do the kind of Boolean searches like the title of X, or I want this term to be in the same paragraph as that term, something like that, and I always found the natural language inquiries weren't as effective. But now a natural language paragraph describing the problem, a good prompt to the AI gives a good answer. So the effectiveness of legal research is undoubtedly enhanced with it. We had databases before, but the ability to access them much more quickly and efficiently is definitely occurring because of AI. And of course, we need to teach our students how to do that. Harder questions, of course, are, should they then just, these same tools, you just hit another button and it'll write a memorandum of law for you or a brief or whatever. And yes, of course, we all know that one should double check the citations and so on to make sure there are no hallucinations. Although, frankly, on the Lexis and the Westlaw databases, there aren't because they're trained on the cases themselves. It's not like ChatGPT or something like that. They're pretty reliable. But it's just that question of to what extent do we want our students to develop skills independently of the technology and then use the technology as a tool to make them more effective? And of course, the worry is that, no, you're not going to independently develop the skills and you're going to be weak in that respect and overly reliant reliant on the AI? That's just the question. It's not just in the law, it runs across education and not only higher education. It's just going to be the issue all educators have to grapple with. Is obviously our students need to know how to use this tech, but they also need to think for themselves.
Well, great challenges ahead, but your book will help us to tackle some of them. Thanks so much, Professor Mark Geistfeld, for joining us from NYU Law to talk about product liability law in the age of AI, your new book from Aspen Publishing. And if you've enjoyed this conversation and would like to listen to additional thought leaders in legal education, I encourage you to check out the additional Aspen Leading Edge podcast episodes wherever you get your favorite podcasts. Thank you.